Hi, my name's Chris Brown from Somerfield Brown Solicitors. I'd like to talk to you today about contract law. I get a lot of inquiries about contract law, and one of the issues is trying to work out the nature of the contract and the contract terms. Sometimes prospective clients say that they're not sure whether there is actually a contract. The starting point for any advice is to determine if there is an agreement between the parties. An agreement is generally formed when there is an offer and acceptance of that offer. There has to be considerations such as some sort of monetary payment, but if all of those are in place, then there is a strong argument that there is an agreement in place. The question then is, what are the terms of the contract? And this is where a lot of clients want guidance. The best case scenario is that there is a formal contract signed by both the parties which contains the contractual terms. However, in many cases there isn't necessarily a formal signed contract, and then it is our job to determine what the contract terms are. Even if there isn't a formal contract, it doesn't mean to say that there are no contractual terms. Contractual terms could be evidenced through email exchanges either before or at the time a contract is formed. Alternatively, terms could be agreed verbally between the parties. Therefore, when a new client comes to see me with a contract dispute and there's no formal contract agreed between them, what I do initially is try to establish whether any terms have actually been incorporated into the contract and therefore govern the contract. And therefore, I tend to ask them to review email or other documentary exchanges such as letters between the parties either before or at the time the contract is formed, to see what those emails say about what was agreed between the parties in terms of performance, criteria for performance. I also ask them to try and recall, or best case scenario, if they've taken minutes of any meetings or telephone calls between them and the other party before the contract is formed. Only when the contractual terms are established can one then provide guidance on the terms of the contract. If there are no terms included in any prior emails or in any conversations between the parties, then one would look to implied terms in any sale of goods contract or supply of services. So before you go to see your lawyer, and in circumstances where there isn't a formal contract, what I would recommend is that you go through and collate all your emails, either before at the time that the contract was performed, to see whether any of those emails contain any terms agreed between the parties. I'd also ask you to try and recall and record any terms agreed verbally, whether they're over the phone or agreed in person. Once you have that information, then your lawyer can analyse it to see what the terms of the contract were, and potentially, if there is any issue in terms of contract performance, whether there is breach of contract or maybe misrepresentation. I'll go into those two heads of claim in another video, but for the time being, if you have an informal contractual arrangement, try and find out what those terms are by looking through all your documentation, your emails, etc., etc. Okay, thank you. Bye.